Good morning. Can everybody hear me okay?
Yes.
Yep. All right, welcome to another oral argument session of the 5th District Court of Appeal. Our first case is case number 20-151. It's Tony G. Taylor as personal representative in the estate of Bobby J. Taylor versus the Airport Restaurant LLC doing business as Airport Restaurant and Gin Mill. As a reminder, we are being recorded and broadcast live on YouTube. I have with us today Judge Nardella from our court and Judge Higbee, who has graciously agreed to sit associate for us. We will reserve 5 minutes for you, Mr. Richardson, for rebuttal, unless you say otherwise.
No, I appreciate that. Thank you.
Okay, that you may proceed.
Thank you and good morning. I'm Adam Richardson and I'm appearing on behalf of the appellant, which is the state. Our argument is that, of course, the court should reverse the summary final judgment entered by the trial court because the trial court erred when it struck portions of Alfred Fisher's affidavit. And as the court knows, because I'm sure it's carefully reviewed everything in the case, Alfred Fisher in the affidavit relayed a hearsay statement that his son made to him, he says, shortly after the fatal accident in this case. And in the statement, he gave a location of where he had been drinking just before the fatal accident. The first issue, though, I think, is what the standard of review is, because that's something that the parties have disputed in the briefs. Our argument in the initial brief was that it should be de novo because this is coming up in the context of a summary judgment proceeding. The airport restaurant says that it should be abuse of discretion because it involves a ruling on the admissibility of evidence. And I think we would maintain that because this is a summary judgment proceeding, that the ruling should be reviewed de novo in light of the special considerations for summary judgment proceeding, which is that it cuts off litigation early and that in general, the standard of review for such a final judgment is de novo. However,
would it be appropriate for us to apply kind of a dual standard as to whether or not the statement was hearsay? We typically apply de novo standard, but as to whether an affidavit should have been stricken, we typically apply abuse of discretion. So do you think it would be appropriate to kind of do a tiered standard here?
A tiered standard, yes, but I think if the court determined that the evidence was admissible hearsay, then I'm not sure if that would necessarily mean that it was an abuse of discretion to strike it. But additionally, as we argued in the reply brief, that even if there was some tiered level of review, or even if formally the court were to apply an abuse of discretion standard of review, in other circumstances, the district courts in this state have applied a much less deferential standard when the evidence is in the same form before the district court as it was in the trial court. And I just wanted to point out that in two of the cases that we cited in our reply brief, it wasn't even something like a paper, like an affidavit that we have in this case, but that it was DVDs of interrogations. So the court was actually looking at what happened, not just a piece of paper, and the courts thoroughly reviewed the recordings in the course of issuing its decision. I just want to point out State versus Sepenick, which is a 2nd district case, and Black versus State, which is a 4th district case. Both of those are cited in the briefs. And the reason, again, that I point that out is even in those circumstances where there is actual video evidence of what happened, so long as it wasn't live testimony, the district courts apply simply a much less deferential standard of review. So even if the court were to not apply a tiered standard, or if it were to apply formally abuse of discretion standard of review, it should give far less deference to the trial court's ruling on the motion to strike than had it been the result of live testimony, where the court could have evaluated credibility of the witnesses. Unless the court has any questions on the standard of review, I'm going to go on to the merits of the case, which is the exceptions that apply. We argue that two exceptions apply: statement against interest and excited utterance. The first one that we've argued in the brief is a statement against interest. And the basic idea is that a person isn't going to make this kind of a statement unless they believed it to be true, something that's so far against their interests, whether it's penal or pecuniary. And of course, the issue in this case is whether the specific at the gin mill statement is against the interest, Douglas Fisher's penal interest.
Can I ask you, I mean, we obviously saw the out-of-state cases, you relied on the Schulman and Zink, I'm not sure how you pronounce that, Z-I-N-C-K. And if I'm not mistaken, both of those statements were given to police officers or investigating officers. Is that correct?
Yes.
So should that factor in at all when we talk about whether something is against, we're instructed to look at the context. And here the statement was given to his father, presumably while he's inebriated. Can you explain to me how those differences are not dispositive of how this case is distinguishable from those?
Yes, I have two answers for that, actually. The first is that while those were the circumstances in Schulman and Zink, the plain language of the statute doesn't require that a statement against penal interest be made directly to a law enforcement officer. It just requires that at the time the person makes the statement, it's sufficiently against that person's interests. So legally, I don't think there's any requirement that the person make the statement to a law enforcement officer, even though that's, of course, what happened in these cases. The second is that although it might be more of, I guess, a slam dunk issue had it been made directly to a law enforcement officer, that doesn't mean that, I guess in the words of the Schulman court, it wasn't likely to lead to significant evidence of wrongdoing. And in fact, that's what those words were used in Masaka, which is the second district case, quoting Williamson, which is, other statements that give the police significant details about the crime may also, depending on the situation, be against the declarant's interest. Admittedly, that says to the police, but for the reason before, I think
yeah, and I think that, there's clearly cases where statements against interest were made to somebody other than police, but I think what is interesting about this case is that, if I understand your argument correctly, that you're relying on the aspect of the statement that it might lead to details of the wrongdoing. And so it's a facially neutral statement in and of itself, but I think your argument here is that it's against his interest because it could lead to details of the wrongdoing. And so that's why I'm trying to understand how a statement made to his father in an inebriated state, why we would, as a matter of law, reach the presumption that that would be likely to lead to additional details.
Yes.
Yeah, go ahead.
Sorry. This was a very serious accident. It was fatal. In fact, Douglas Fisher fled the scene immediately after the accident, and he had to be apprehended a little in the area of the accident because he didn't flee that far. The seriousness of the accident, the fatality, it should have, or it could have, led the officers to conduct, as we say in their brief, a more searching inquiry of his whereabouts before the fatal accident, including where he had been and how much he had been drinking. And I suppose that could be said that I'm engaging in more speculation or surmise, but I think it is reasonable that an officer would have contacted this gentleman's family, maybe including his father, just to get see if he knew where his own son had been. So I think that would have been the link between the fact that the statement was made to the father and whether the statement would have been would have led to any significant evidence of wrongdoing. That a different kind of investigation, one that wasn't done here, might have turned this up.
Mr. Richardson, doesn't that depend upon the defendant going through some great thought process? Isn't the whole basis of the exception to the hearsay rule against your own interest that we find it more reliable, this statement, that you would say something that would hurt you in the future. But isn't it a little attenuated to say, not only did he say something that would hurt him, but he'd have to think they would hurt him because he'd have to think there'd be an investigation where his father would be interviewed. It requires great thought process for somebody who we all acknowledge was extremely inebriated at the time of the accident. Should that factor in the analysis at all when we come to the foundational reason why we have this exception to begin with?
I think that's more applicable to the excited utterance exception because that more clearly places at issue whether the person has been able to engage in reflective thought. But I don't think that that does make it more attenuated in the statement against interest context, because at the time, of course, he couldn't have known what was going to happen, but he obviously would have known that he had been drinking somewhere. In fact, that there was a location where he had gotten intoxicated, and that the fact that he had gotten intoxicated there probably didn't look good for him. I don't think it was necessary then to go into, I think what you're getting at, which is a more sophisticated thought process of exactly how that information would have come out. It's just that at the time he made the statement, would it have been so far against his interest that he would not have made it if it had not been true? And I think under the plain language of the statute, that is true here, that he wouldn't have made it if he thought it was a false statement or not something that was clearly true.
Counsel, how do you distinguish Perez and Moscatello?
Perez and Moscatello are...
So Perez is the case where the gentleman commits the burglary and he admits that he did it, but he says, I did it with the fish, which was the name of his co-conspirator, his co-criminal participant. In the court, the third DCA in that case affirmed the trial court's decision to exclude the identification of the co-defendant.
I think that's slightly different because it's difficult. I think this is not going to be a satisfying answer, but I think it has to be done on a case-by-case basis. Although other precedent is helpful, it's not necessarily that helpful because of the intensely factual nature of these cases. The fact that the person identified someone else in that case is not inculpatory because obviously they're trying to throw off the blame onto someone else. It's not like here, Douglas Fisher is trying to do that. He's not by saying that he got drunk at the gin mill trying to throw off criminal liability onto anyone else. It's still solely about himself, which is his actions and where he got intoxicated. So I think in a case like that, it's more clear that it's not inculpatory than it is in this case.
Do you know whether the record reflects whether the statement was made after the blood draw or before?
That is interesting because of the different pieces of evidence in the record, but in more carefully reviewing the record from preparation for this OA, I think what happened is that the statement was made well before the blood draw. As I said earlier, he fled the scene, and he remembers, although he doesn't remember anything else, remembers making this call to his father at the shop. And the shop was located near the airport. Depending on what evidence can be considered here, that is around where he was found at the shop. And that was before he was detained. He went from the scene of the accident, depending on what evidence can be considered right now, to the shop, left the shop, and then was detained when he was walking away from there. So that was before he was formally placed under arrest and a blood draw was made.
And before we get into your rebuttal time, I want to make sure that we addressed your tipsy coachman argument.
Yes.
I think, the global rule is that if there's anything in the record to affirm, so sometimes there might be a ruling necessary. So why is our record not complete here to affirm on tipsy coachman? We've obviously know your arguments as to why tipsy coachman not be appropriate even if those applied, but why is the record not insufficient here to not apply tipsy coachman?
assuming it applies, I think that the record is not sufficient to affirm because there are other elements of the dram shop action that there are genuine disputes over. There are genuine disputes over whether the airport restaurant knew that he was a habitual drunkard. The evidence shows that he frequented there a lot from when he left prison in late 2014 to early 2015 until this accident in June 2017, on average of once a week. And in the case, sorry, let me pull up my notes real quick. In Ellis, which is the Supreme Court case, the court specifically said in discussing circumstantial evidence that serving an individual a substantial number of drinks on multiple occasions would be circumstantial evidence to be considered by the jury in determining whether the vendor knew that the person was a habitual drunkard. Here, Douglas Fisher's testimony very clearly satisfies that. And for that reason, on those other two elements of the dram shop action, there was sufficient evidence to avoid summary judgment if the court were to apply tipsy coachman doctrine. And then if there's nothing further, I'll reserve the rest of my time for rebuttal.
Thank you. Mr. Tinker, whenever you're ready.
May it please the court, good morning. Mark Tinker and Therese Savona on behalf of Airport Restaurant. I'd like to start where you ended, Judge Sasso, with the tipsy coachman issue. That is something that I think is extremely important in this case, because as much as Mr. Richardson has discussed the hearsay exceptions in this affidavit, and that was the focus of the briefing, all of that goes to placing this gentleman at the gin mill. And that's all it does. What it does not do is rebut the affirmative evidence that nobody at the gin mill knew that this gentleman was an alcoholic, knew that he had a problem with drinking, and knowingly served him that night. The affidavit that we've been discussing, filed by the father, he goes through and provides his own opinions of his son's alcoholism and says, I've known he's been an alcoholic. I know that he can't stop drinking. It's talking about his own knowledge about his own son. It says nothing about what the gin mill knew. The affirmative evidence that's in there is that the people at the gin mill did not know who he was, that he said, I didn't even know the bartenders or the waiters. I sat in different places. I didn't talk to anybody. Nobody really knew who I was. We don't know anything about that night, who specifically served him, where he sat. He said, sometimes I sit inside at the bar, sometimes at a table, usually outside. We don't know where he was, who served him, what they knew. So in the face of the affirmative evidence that's in the interrogatories saying that the gin mill did not have any knowledge that this gentleman was an alcoholic, there's nothing to rebut that, no matter what we do with this affidavit. So I think that's critically important for that reason. And Judge Sasso, as you said, the rule is if there's something in the evidence, if the evidence is developed and the court can rely on it, all of that is in this file. At the end of the summary judgment hearing, when the judge made her ruling, Judge Weston ruled, there was actually a discussion of, is there anything else that needs to be done? Is there outstanding discovery? And Taylor very briefly said, well, maybe there is more discovery. Maybe we'd like a continuance so that we can conduct it. And when Judge Weston asked what that was, it was to interview more witnesses who could put him in more proximity to the scene to try to establish that he was at the gin mill. So we're just looking at that same issue again. It still doesn't get to, did anybody knowingly serve him? So even, there's nothing else that was outstanding. There's nothing that was identified as being outstanding. The evidence that is in this record after 2 continuances of the summary judgment hearing is that the affirmative proof in the interrogatories, the restaurant did not know. The response is, we don't even know who served him. Nobody there knew he was an alcoholic. There's no way to establish any liability regardless of what we do with this affidavit.
So there's a quotation and that's highlighted in the reply brief regarding Officer Florence's statement that essentially went to the airport, or he or she, I'm not sure. The officer went to the airport and somebody said something along the lines of they knew he would frequent there, but they can't really remember him being there prior to the crash. Is that just insufficient in your mind to create an issue of fact?
Absolutely. I think that's as close as it got. And to say that we think that this person frequents here, that doesn't establish anything to say we think this person's an alcoholic. And it doesn't mean that that is the individual who was serving him that night and knowingly served an alcoholic, which is the test for dram shop liability. So to interview anybody that, when the police officer walked in, and when I'm not even sure exactly when that was, if it was the same people who had been working at the time that he was there. So that's utterly insufficient to rebut the affirmative proof that's in the record.
And are you familiar with the Stark case cited, Stark versus State Farm, and appellant highlighted footnote 4, where the court declined to affirm and on alternative ground on a motion for summary judgment? How would you either distinguish this case, or do you think that case was properly decided?
Well, I think it was properly decided, but it's distinguishable in both of the cases that Taylor cited. There was both Stark and Akers. They involved parties that received a ruling trying to go off onto different theories that had not been developed. Stark was actually a coverage case, and there was a summary judgment issued on the finding that State Farm was prejudiced by late notice that was provided for a claim under this policy. And State Farm said, well, if you don't find for us on that, there are these other post-loss duties that also weren't complied with. So now it's going off onto, not just a question of notice, but what were these other duties? Did the insured comply with them? And can you prove prejudice resulting from those specific failures as well? So those are completely separate issues that on that record, it doesn't say, the opinion doesn't even identify what these other post-loss duties are, but what, whether those were in existence, whether they were violated, and what the prejudice was, those would be collateral issues that would have to be developed in the first instance by the trial court. And I brought up Akers because I believe Stark cites to Akers, or vice versa. They kind of rely on each other. And they were the similar thing. Akers was a summary judgment on workers' compensation immunity. And the alleged tipsy coachman argument there was to say, if the employer isn't immune, well, then there's not enough evidence to find negligence on their part. So it's going past the immunity issue, and now we're starting to litigate the actual merits of the negligence issue. So both of those courts said that's not a tipsy coachman issue. You're asking us to make rulings in the first instance on issues that were not decided. This is completely different because we're talking about one issue, the dram shop liability. It has those elements that have been enumerated. They were set forth in the motion for summary judgment, saying here's our affirmative proof that the plaintiff did not satisfy them. The plaintiff presented their evidence claiming that they did. Those are all on the same 4 elements, and that's what was decided. And if you look also at the summary judgment hearing on this matter, the judge was asked, do you want us to go over these other elements? This was on page 597 of the record. And she actually said, no, you don't need to continue. So the evidence was there, and they were prepared to address it with her and say, here's all of our proof on these other issues. And she said, no need, I've already decided this one, so the rest of it is moot. And that's really where we are with this court, to say we believe that we went on the one that she decided. But if you disagree, all of the evidence is there the same way as it was before Judge Weston at the hearing. And it shows that there's no knowledge that this person was an alcoholic, or who knowingly served him, knowing that he was an alcoholic. It was kind of a long answer to a short question. I apologize for that. As far as, just to address briefly, the 2 arguments, as far as the statement against interest exception, I believe, Judge Nardella, you're kind of focused in on aren't we looking at whether this has credibility to it because of who it was said to, and wasn't this his dad? And that's critical. You question the importance of that. All of the cases that were cited are to law enforcement, and certainly it doesn't have to be a statement made to law enforcement to be against interest. It could be to another bystander at the scene, or somebody like that who might be testifying or might be giving witness to what happened. But when you leave a scene of an accident, you go to your father's office and you call your dad and tell him what happened, that's not against interest to say, I came from the gin mill. There's nothing about that he's going to inculpate himself. Now, I understand the part of it's to say, I'd been drinking and I drove. That could be something that's against his interest, because there is record evidence that his dad paid his car insurance, his dad paid his cell phone bill, his dad's going to be mad at him for doing this. That's against his interest to tell his father that. But saying I came from the gin mill is not. There's nothing about that is against his interest, against his penal interest, or anything of the sort. And to be honest, if you look at it in the context of what we're doing here today, it actually is something that could be to his benefit to try to say, bring somebody else into the fold for liability, to say, yes, I was drinking, but I came from that other establishment. They served me. That's why we're here today. He's having someone join him for potential liability. So it's not against his interest to provide that testimony. The others alleged exception was the excited utterance. And the big issue there is we don't know the time that passed between this accident and when he gave this statement to his father. We do know, according to him, that he left and drove to the office before he did it. The argument that was, I'll say, popular in the brief was that, well, yes, but he was intoxicated, so he didn't have time to form, he wouldn't have the ability to form rational thought or to come up with a contrive or misrepresent, or the words used by the exception. And I completely disagree with that. An intoxicated person may not form rational thought, but an intoxicated person is going to justify, make excuses. They're going to have plenty of thoughts, and they're going to come up with stories, and they're going to say a lot of things. So by the time he left the accident scene and drove to the office and then called his father, he had plenty of time to think about what had just occurred and to change his story, to think, reflect on it and decide, here's how I want to present this. That is not an excited utterance. It was not spontaneous. He wasn't under any duress. He was talking to his father about what just happened, and probably in his mind trying to justify what just happened. So those are my notes on what was discussed. Well, the argument began with the standard of review, and I don't think one way or another that's a big deal. I agree with your interpretation, Judge Sasso, that I think it's mixed. I think the hearsay portion, as far as how the rule applies, the case law says that is a de novo standard. The court can look at that just the same as the trial judge did. But the difference as far as the striking the affidavit, I think it's critical that this wasn't just an all-out striking even. The judge went kind of a line item and parsed out the portions. And I believe that's a discretionary decision for the judge to sit down and say, here's what I think is covered, here's what I think is not covered. That was within the trial judge's discretion. So I believe what she did there is certainly under an abuse of discretion standard. But again, I don't think that matters one way or another, given the impropriety of the affidavit and given the tipsy coachman issue, that regardless of this affidavit, all that does is put him at the gin mill. It doesn't say how much he drank there, whether he drank anywhere else before or after, how much, who served him, whether they knowingly served him, whether they knew he was an alcoholic when they served him. None of those things are established, but the affirmative evidence in the interrogatories is to the contrary. So unless you have any other questions, I simply ask that you affirm. Thank you.
Thank you.
I have just a few points in rebuttal. The first is, I'm going to go to is the tipsy coachman doctrine, that the general idea that the people at the gin mill didn't know him, that is somewhat supported by Douglas Fisher's deposition testimony. But as one of the judges mentioned, Officer Floriance went there and they said that he frequented the airport restaurant. And it's also, I don't think, relevant necessarily for admissibility whether he was able to identify the bartenders, or whether bartenders would be able to whether he would be able to identify any bartenders, because that would go more toward the weight of the evidence, whether the testimony is believable by the jury. Additionally, the employee knowledge is imputed to the employer, here the defendant. So whether one individual employee knew this person, Douglas Fisher, before having served him any particular time is also not relevant. It's whether collectively the employer knew from all this imputed knowledge whether he was a habitual drunkard. As for the statement against interest argument, the argument that I heard was that he had enough time to figure out that he could bring the airport restaurant into a possible civil action. And I don't think that's supported by the record. I don't think that makes a lot of sense, that at this time, this person under these circumstances would have been able to sit down in his father's shop and say, you know what, I think that I may be sued civilly for this, and I know about the Dram Shop Act, so I better come up with someone else to blame. So I don't think that establishes any kind of attenuation or any kind of suggestion that he had an incentive to lie. I think that the evidence actually establishes that he did not have the incentive to lie at that time in those circumstances. As for the excited utterance exception, the defense minimizes the startling event. It's not like he had this accident. He, ambled over to his father's shop. He made a call to his father like, hey, Dad, this is what happened. Check it out. This was a fatal accident where he fled the scene and basically sought refuge at his father's shop. This was something where at the time he made the statement, he was close enough in time to the startling event and would have been, in our view, still under the stress of the startling event. So I think that the defense argument does minimize exactly what happened here in talking about whether this was an excited utterance. Additionally, the fact that Douglas Fisher was severely intoxicated is severely or significantly relevant to whether or not he had the capacity to reflect on what he was talking about. It may be true that when people are intoxicated, they say whatever they want, but it's not clear, at least from here, that the fact that he was severely intoxicated would have led him to lie about where he was drinking. And additionally, the statement of the law is that when the time interval is long enough to permit reflective thought, all we have to do is provide some proof that the declarant did not engage in reflective thought process. And I think that some proof is the fact that he was very intoxicated. And unless the court has any further questions, that's all I have in rebuttal.
Thank you both for your arguments today. Well